Creating a legally sound S-corporation operating agreement is essential for defining your business structure and protecting shareholder interests. While S-corporations primarily rely on corporate bylaws and articles of incorporation, an operating agreement provides additional clarity on roles, responsibilities, and operational procedures. An S-corporation operating agreement serves as a foundational document that outlines how the business will be structured and operated. Though not legally required in all states, this document helps prevent disputes by clearly defining shareholder expectations, governance procedures, and financial obligations. When organizing a new corporation, it's important to understand state-specific requirements. Corporate bylaws provide details on how the corporation will conduct and manage its business. These bylaws don't need to be filed with the state, but are legally required documents that serve as the final word on resolving conflicts or issues. To qualify for S-corporation status, a company must meet specific criteria established by the Internal Revenue Service. These requirements include issuing only one class of stock, limiting shareholders to 100, ensuring all shareholders are United States citizens, and prohibiting corporations and partnerships from purchasing company stock. Failing to meet these conditions during a tax year will result in the company being treated as a C corporation for tax purposes. The key aspects covered in an S-corporation operating agreement include ownership structure, voting rights, share transfers and restrictions, profit distribution, and dissolution processes. The ownership structure defines shareholder roles, responsibilities, and percentage ownership. Voting rights establish how decisions are made and outline voting procedures. Share transfer rules specify how shares can be sold or transferred. Profit distribution clauses determine how and when shareholders receive distributions. The dissolution process outlines procedures in case of company closure or major structural changes. In contrast, limited liability companies utilize operating agreements that include company information, member roles and responsibilities, share ownership, guidelines for accounting and meetings, and procedures for dissolving or selling the company. When customizing your S-corporation operating agreement, several essential clauses should be included. Business information such as name, address, and purpose of the corporation, ownership and shares information detailing how shares are allocated, and any restrictions on stock transfers. Management structure defining the roles of directors, officers, and shareholders in decision-making. Profit and loss allocation explaining how and when distributions are made. Meeting and voting procedures outlining the frequency of meetings and voting rules. Shareholder buyout provisions providing guidelines for selling or exiting ownership stakes. Dissolution clauses stating conditions for dissolving the corporation. And dispute resolution procedures establishing legal steps for resolving disagreements. Articles of incorporation must be filed with the state and include the legal company name, address, contact information, names of officers, business purpose, number of stock shares issued, and voting rights for each share. While operating agreements and corporate bylaws share similarities, they serve different functions. Operating agreements define shareholder agreements and operational rules with more flexibility for customization. Corporate bylaws establish corporate structure and governance, are required in most states, and are governed by state corporate laws. Creating a legally sound S-corporation operating agreement involves adherence to federal and state laws. Each state has different rules regarding corporate governance. The agreement must align with S-corporation tax structures, including pass-through taxation rules. Shareholder agreements must comply with federal securities laws if applicable, and the agreement must be legally enforceable to prevent disputes. Though not required by law, having an S-corporation operating agreement can prevent conflicts among shareholders and clarify company policies. While free templates are available, it's advisable to tailor them to your specific business needs and state laws. Failing to follow the operating agreement may lead to shareholder disputes or tax issues with potential legal consequences. For the best results, consider working with a business attorney or legal expert who can draft or review your document for compliance and accuracy. This investment helps ensure your S-corporation operates smoothly while maintaining its valuable tax benefits and legal protections.